Namaskar and very warm welcome to all of you joining us today on this important topic of living wills and the landmark decision of Justice M.S. Sonak of Bombay High Court's Goa bench to register Goa's first living will. Now, in a historic move, Justice M.S. Sonak recently became the first person in the state of Goa to register a living will, setting a precedent for others to follow. Goa has thus become the first state in India to formally implement the Supreme Court's directives on living wills and passive euthanasia. The process of registering a living will in Goa involves drafting the will in the presence of two witnesses, getting it attested by the gazetted officer or notary, and submitting it to the district collector's office for safekeeping. Now, to begin with, let's understand what a living will is. A living will is also known as an advance medical directive. It is a legal document that allows individuals to outline their preferences for medical treatment in the event they become incapacitated and unable to make decisions for themselves. It enables individuals to refuse or consent to specific medical treatments such as life-sustaining measures in case of terminal illness or persistent vegetative state. Now, let's discuss the procedure for the implementation of living will in India as per the Supreme Court guidelines. Now, Supreme Court, when it gave these particular guidelines in the case of common cause, they even attested certain qualifications, the validity of these living wills. One of the qualifications is that the person has to be of age which is above 18, has to be major, has to have certain kind of physical distress which is causing them to not live their life to the extent, for example, being in a vegetative state. Here, the person's right to life with dignity is compromised. Now, keeping in mind all of these things, these guidelines were pronounced by Supreme Court. Now, when we discuss, let's discuss what is the procedure of a living will first. Now, first, the healthcare providers must verify the authenticity and validity of the living will. Now, the validity is established under the Supreme Court guidelines, and this validity needs to be checked with consonance with judicial magistrate first class who is concerned before acting upon it. Next, a medical board comprising experienced healthcare profession should review the patient's condition and certify the applicability of living will. Following this, the judicial magistrate of first class should visit the patient, examine the relevant aspects and authorize the implementation of living will if satisfied with its validity and applicability. Provisions have also been made for revocation or renewal of living wills, considering the potential for change in circumstances or preferences over time. Now, Goa implemented these rules requiring living wills to be attested by a notary or a gazetted officer and stored by the State Revenue Department office, setting a precedent for others to follow. But what exactly is euthanasia and how does it relate to the concept of living will? Now, euthanasia is derived from a Greek word which meaning good death, and it refers to the practice of intentionally ending a person's life to relieve them from the suffering. Now, there are two main types of euthanasia. Firstly, active euthanasia. It involves intentionally causing a person's death through direct action, such as administering a lethal injection. On the other hand, passive euthanasia refers to withholding or withdrawing life-sustaining treatment, allowing a person to die naturally from the underlying conditions. Now, active euthanasia is present in countries like Switzerland, whereas India allows passive euthanasia only. That means that it can, in India, only a withdrawal or withholding of life-sustaining treatment is allowed, so that the person dies a natural death due to their underlying condition. Now, in India, the Supreme Court has played a pivotal role in shaping the legal landscape around the euthanasia and living wills. Now, before the landmark judgment of 2011 in the case of Aruna Ramchandra Shanbag versus Union of India, the Supreme Court was not in the favor of the concept of euthanasia, be it active or passive. Now, in this case of Aruna Shanbag versus Union of India of 2011, the court recognized the legality of passive euthanasia in certain circumstances and the need for advance directives. But it did not provide any specific guidelines for living will in this particular judgment. But it was the 2018 judgment in Common Cause versus Union of India that upheld the legality of passive euthanasia and laid down detailed guidelines for the execution and implementation of living wills in India. The judgment recognized the principles of patient autonomy, self-determination, human dignity as enshrined in Article 21 of the Constitution of India. Now, talking about the international scenario, internationally several notable cases have also shaped the discourse around euthanasia and the right to refuse medical treatment. In the United States, the case Curzon versus Director of Missouri Department of Health in 1990 established a constitutional right to refuse life-sustaining medical treatment, paving the way for passive euthanasia. Similarly, in Canada, the Rodriguez versus British Columbia case in 1993 affirmed the permissibility of passive euthanasia while declaring active euthanasia impermissible. And in the case of Waco versus CUET, which took place in 1997, the US Supreme Court held that the right to refuse unwanted medical treatment or passive euthanasia is permissible while assisted suicide or active euthanasia is not protected by the Constitution of United States of America. Now, in conclusion, the registration of Goa's first living will by Justice M.S. Sonak is a significant milestone in the state's journey as well as the country's journey towards respecting personal autonomy of the patient and self-determination in end-of-life decisions. Living wills protect an individual's autonomy and right to die with dignity, and Goa has taken a pioneering step in implementing the Supreme Court's directives on this matter. Proper procedures, safeguards are now in place to ensure the ethical and legal implementation of living wills in the state. This development highlights the importance of having open conversations about end-of-life care and making informed decisions to ensure our wishes are respected in the event we are incapacitated. So I hope this comprehensive overview has shed a light on the concept of living wills, the legal developments surrounding euthanasia, and the significance of Goa's groundbreaking move. Thank you so much for joining us. I encourage you to continue exploring this topic further and engage in discussions with people around you about the personal preferences of theirs for end-of-life care. Thank you so much for watching. If you liked the video, please like and please share your comments and questions in the comment box, and share this video with like-minded people who would benefit from such an informative video. Thank you so much for watching. Subscribe to Pratham Test Prep channel for more such informative videos. Thank you and all the best.